Can everyone hear me? Right, we're using ear mics for today. Now, for the question and answer session, we have a mic set up in the middle of the hall. So if you have a question for our speakers, please just come up to the mic, state your name, where you're from, and just shoot the questions to the speakers. If there's a particular speaker you'd like to address, please just address the question to that speaker. If not, just we'll open it to the floor. Anybody who would like to kick things off? This is a golden opportunity. You have a very, very esteemed panel of speakers with us. So please take the opportunity to ask what you wish. I know it's close to lunchtime, but yes, thank you.
Yeah, good afternoon. My name is Rob Mao. I'm from the Squash Association of Malaysia. I'm also a practicing lawyer. My question is, for the players, especially the junior players, joining competition organized by the Sports Association, how do you relate it contractually? How do we bind that? As you know, we don't do any contracts or agreements with players, junior players. So let's say the junior players have been training to play the national competition and they are not selected, they are not happy, the parents are not happy. They go to the court. Can they go to the court to challenge the decision?
Is there any particular panelist you would like to address the question to?
Maybe Justice Mao would be in a better position. As you were saying, this is not open to judicial review just now.
That's right.
Well, I would have thought that any athlete wanting to take part would join any association. There will be rules and regulations of that association governing the sport. And or if they become a member of that sport, they will have to follow the rules of that association. But there's a question asking whether there should be contracts signed between the athlete and the association. Is that what you are saying?
Especially for our competition where it involves junior, they are under 18. So they are not members of the association. So we organize a lot of junior tournaments where issues of selections, even like to go for the old British Junior Championships where quite a lot of money at stakes, reputation at stakes, where your son or daughter are not being picked, not selected. So it creates a contractual relationship there.
It would be a better idea to have contracts signed and have all the terms spelled out.
To be signed with the guardians of
probably that's the way to go. Sorry?
To be signed with the parents.
Yes, say again.
To be signed with who? With the players? They are junior players, under 11, under 13 players.
The parents will sign on their behalf as guardian.
Yeah, I think legally speaking, minors are not, I think it's tried that minors are not entitled to enter into contracts. So normally, except where it's for necessaries like food, clothing, etc. I stand to be corrected, of course, Justice Ma. But if it's under 13 or under 18, then it would be their guardians or parents who should sign the contracts for these. I think for avoidance of dispute, it's always best to have things in black and white if the rules and regulations do not cover it.
You find that with the Olympic sport, quite frequently with gymnasts, often they'll be under majority, and their parent or guardian will sign the relevant Olympic team agreement on their behalf. But I think Justice Ma makes the point quite powerfully that the squash federation or the squash clubs are vulnerable to the absence of a contract, and even if you have it included in the form of a membership agreement where they pay their nominal membership subscription per year, and as a consequence of buying a membership, the participant agrees to be bound by the rules and regulations in force from time to time of the club and of the National Squash Federation, etc., then you'll bring them into the contractual suite of documents which informs the relationship between them and their club under the membership agreement. The second thing to do is something Australia and also Britain has done particularly well in the last decade, is to have very clear selection policies They don't have to be exhaustive, but just in writing, bullet point form, knowing where the bar is going to be set and what you have to do to clear the bar to achieve selection. The large majority of selection disputes that clogged up the Court of Arbitration for Sport in an Olympic year, certainly in Australia, are much less than they once were because of the initiative of the Australian Olympic Committee in sitting on all of its relevant sports, all of the different national federations to have very clear selection guidelines so that there wouldn't be any ambiguity in the selection guidelines giving rise to selection disputes. And that's also been done very, very well in Britain. So they're the two things I think you need to focus on. Firstly, membership agreement, which incorporates all of the rules and regulations enforced from time to time, signed on behalf of the minor by their parent or guardian. We just have a very simple, clear, one-page bullet point document setting out what the selection policy is and ultimately leaving the discretion on any subjective factors to the selectors, which the participant agrees they won't enter into any correspondence about. That should solve the problem.
If I may add to that answer, I can only think of an example of a case which went to court. It was a question of eligibility, question of selection. Nothing to do with sports. This was a debating team. I think you know which case I'm referring to. Some very prominent former retired judge, where he claimed to have there was bias or prejudice against his non-selection to be in the debating team, and that case ended up in court. So I don't believe there would have been an agreement signed, but on the basis that there was no fair play and rules of natural justice didn't apply, perhaps, that the case was actually filed in court as a last resort.
Thank you, Mrs. Are there any other questions? Anyone?
I have a question for Justice
Oh.
Judge, in the very comprehensive details of cases involving disputes within an association under Malaysian association law, to what extent does livelihood play a role in determining whether or not the court will intervene in the affairs of a voluntary organisation or association?
Whether the association will continue.
Indeed, what about will be justiciable? Does livelihood play any role in that? Because I thought it was interesting when you set out the basis upon which Malaysian courts will intervene in Australia and certainly in Britain. Jockey Club case in Britain, Cameron and Hogan in Australia. Courts are very reluctant to intervene unless there is an infringement of legal right and someone's livelihood is at stake. Is that something that often comes up in Malaysia, or would you say Malaysian courts are much quicker to intervene?
Well, personally, I have not come across a case in that court or any of the decided cases that I'm looking at. But I for one like to push boundaries, and I think it's an absolutely good idea to consider that, because I think that comes along with fair play as well.
Yes.
Yeah. At the end of the day, it's to do justice and see whether everybody can be accommodated and be happy with the decision. Okay, yes. Short answer would be yes.
Yeah. So you had a question? Yes. Yes.
Thank you. My name is Weng, Sports Fraternity Secretary. I'm also a practicing lawyer. I would like to zoom in my question, which is an issue that can be discussed by the panel, with regards to what Justice Ma raised earlier about the sports development act, which has got provisions in the act which can solve problems in a speedy, certain and final manner. And of course, the section 23 and 24 referred by Justice Ma and also Mr. Paul. Although it looks well drafted, well
prepared for any issues that comes up in sports association, but it really does not work in practical days at the playing field. I mean, I want to give you an example without giving out names. There was a situation in the Olympic Council of Malaysia itself. I was a former office bearer of the Olympic Council of Malaysia. I was the assistant secretary. There was an issue against an office bearer where he did not follow certain rules, and the committee decided to question him. The matter was brought up to the board, they discussed it, brought up to the council meeting, they discussed it, they couldn't resolve it. There was a complaint lodged to the commissioner's office. The commissioner looked at the complaint and said, look, he obviously couldn't find a way out of it because it involves some high-profile personalities. Then he said, I've got a way out of this. Look at section 23. You have to solve your problem and solve it according to your internal dispute manner, or whatever prescribed rules you have. But then again, if we look at section 23 carefully, although the Act requires the sports bodies to resolve all their disputes internally, the last 4 words of the section is often missed. The last 4 sections says, prescribed by the regulations. Now these regulations are from within the Sports Act. Now when we check the Sports Development Act, when I approach the authority, the Sports Commissioner's office, they have a regulation for registration of sports bodies, disqualification of office bearers, and of course the appointment of the Sports Advisory Panel members. They have 3. They don't have a regulation set up for internal dispute resolution. So how then would Section 23 apply? Because Section 23, if I may just paraphrase, it says, sports body shall resolve any dispute arising amongst its members or its committee and the body in accordance with the internal procedures prescribed in the regulations. So when we flip through the Act, there's no regulation. Hence, Section 24 cannot kick in. Because only if you fail Section 23, where the aggrieved sports body, the issues are not solved, then you go to the minister. So how then can the minister come in and solve the problem? Because we have Section 23 failing because it doesn't have a regulation. Then Section 4, the minister can come in. So this is what's happening with the administration in sports bodies in this country. They have a real problem of solving issues. A recent example you have read in the papers about involving doping in athletes. A huge group of athletes, 60 of them with coaches, sent in a complaint to the sports body saying that a certain official was involved, personally involved in doping. He encouraged doping, he encouraged athletes to be administered with banned substance. And it ended there. What happened was he did not go up to the Sports Commissioner's office. The anti-doping agency in Malaysia in charge of it, RWY, has not looked at it until today. This was a matter that happened during the SEA Games in Jakarta. And people seem to be just closing, I mean, we have this syndrome, we're closing one eye syndrome. That's going on in sport. It's a very real syndrome that's going on. So how do we then, this Act came in 1997. To date, Section 23 and 24 has not been put to test. The matter that went up to court in 2005, as this Ma showed us down, 2005, Jin Mi Kyong, that was a case involving Taekwondo, because then we really relied on the personality of the commissioner. If the commissioner is of a strong personality, then he'll say, hey, you go back and solve this because the Act says you have to follow the internal dispute procedure. Of course, office bearers are sports people generally. They have no legal background. Of course, with some exceptions of few personalities who are lawyers who are in sports. Then they go back and they try to solve that. And this personality, the sports commissioner, when he's too strong, he pushes you enough, then they go to court. That's how Jin Mi Kyong ended up in court. Because the problem with the Act is really simple. The commissioner, like Justice Ma pointed out, you can register the sports body and you can suspend or deregister the sports body. Guess what? You can't do anything in between. That's what the Act is about. So the sports bodies really have no remedy apart from having the KLRCA now, which is coming through the Olympic Council of Malaysia, and Mr. Paul or any members of the KLRCA can confirm there are no matters that has been forwarded by the OCM to the KLRCA. So how do we reconcile all this? How do we reconcile the Act, which is incomplete, and the associations where people are incompetent in law in dealing with dispute resolution? How do we do this? I leave this to the whole panel to probably bring this up as a discussion. Thank you.
Thank you.
Thank you for the question. There are two very brief things I have to say in response to it. Firstly, you're concerned that the OCM has preferred the KLRCA may perhaps be premature, because this is something which is being looked at the moment between the OCM, National Sports Council, government, and also the KLRCA. But nothing has been put in place yet. Secondly, your concerns with respect to sections 23 and 24 of the Sports Development Act. Those provisions of the Act are currently being looked at, and they may be subject to review in the coming year. Thirdly, with respect to your concerns about sports dispute resolution generally, might I suggest the model I proposed towards the end of my address, the sports arbitration model, would go a long way towards achieving that end. And bearing in mind those three things, let's see what happens in the next 12 months.
That was a long and difficult question. Probably would have been easier for me to be. I should have come here this morning. Stayed in court and hear one of the run-of-the-mill appeals would have been easier. But I think the short answer would be this. If the regulations are still not being drafted and still not formulated, then obviously something is quite wrong. The Act is fairly old now. And I think that sports bodies really must form a lobby and ensure that these regulations do come into place. But I think what happens, of course, is that when you have a domestic inquiry and a matter is heard, and they refer to regulations which are non-existent, there you are, you already have a question of law, and it won't be very difficult for you then to apply for review. As I mentioned just now, when you come to court for judicial review, it's a two-stage process. First is to obtain leave, and then once leave is granted, you file in your formal application. But in a case like this, where question of law is involved, leave is quite readily granted, so you can then take the matter up. But my caveat only is that what I've said earlier is that in a review case, this is not an appeal against the decision of a domestic inquiry. It's merely to watch and check on the procedural fairness that all the various provisions have been applied. So common sense would tell me that if they're relying on rules and regulations which do not exist, then what are they talking about? So surely you have a case to complain.
Yeah, thank you, Justice Ma. Okay, I think due to an unfortunate constraint of time, that is all the questions we will have for today. Can I just give the panel speakers a big round of applause? I'll hand over proceedings back to the MC. Can I just invite the speakers to just stay on the stage for just a short while more? There's a short prize presentation for all of us.
Yes, can we just invite Mr. Yip to present a token of appreciation to our panel of speakers? Justice Ma, can I invite you to the stage? Mr. Paul Hayes. Encik Isa Aziz. Thank you very much to all our speakers and to our moderator. Well, I think we've discovered that there is